You are recording.
Okay, I think we're ready to start. Guys, are we ready to start?
We are.
Yes,
Okay.
yes, sir.
Greetings, everyone. I'm Stuart Suskin. Today, I'm pleased to introduce this first in a series of programs entitled Meet the Experts. Thanks to the incredible support that I've received already from Deputy Chief Judge David Langham, we were able to develop a platform where we can provide you guys, the workers' comp attorneys, and the claims professional community with some really useful day-to-day practice tips that you can consider to enhance your own practice skill and skill set without having to pay for a registration fee and to receive CLE and CEU credits to boot. Let me stress, so there's no misunderstanding, this project does not replace the valuable case law and statutory information you guys receive at section-sponsored lunch and learns, the forum, or the comp convention. And besides, we don't provide meals, free drink tickets, or live music. So we have been approved for CLE and CEU credit. The bar course number will be furnished or flashed across the screen at the end of the program. For all of you claims professionals that are in attendance, you have to fill out an affidavit. You can obtain that for your CEU credits by emailing the WCCP administrator, Tanya Griffin, or executive
Oh, you want
director.
me to forward you the link? I have the link, but I can't get it.
Judge, are you going to mute everyone?
They
Thanks.
should be muted.
Okay. Um,
Stuart, you're muted.
Unmute me?
There you are. You're unmuted. I'm
Okay,
sorry.
there we go. That's okay. That's okay. Let me just let me repeat for the claims professionals. There's an affidavit you need to fill out. You obtain that from Tanya Griffin or the executive director, Stacy Hosman. So you can email either Tanya and spelled Tanyea Griffin. Well, just the email is Tanya or Stacy, Stacy, at Hossman Associates.com. The bios, to save time, the bios have all been furnished to you in the invitation. You guys hopefully will be muted so we avoid background noises. Questions you can pose in the chat. Finally, the Meet the Expert series will be held every third Friday of the month at noon from September through June. So mark your calendars. Next month's program is scheduled for February 20. We'll be featuring Glenn Whelan, Dawn Traverso, and Brian Greenberg to discuss critical and practical practice tips. I also want to recognize that I will be assisted by Judges Lourdes and Cerny, Jeff Jacobs, and Eric Grindle, along with Judge Langham, to develop future program topics and speakers. So I guess the word to the wise is if you ever want to be a speaker on this platform, don't piss off any of these judges. Just kidding. Maybe. Anyway, now I'm turning the program over to former Judge Steve Rosen. Judge, start the discussion.
Thank you, Stuart. Good afternoon to all of you attendees, and thank you very much for attending. And as is the purpose of this seminar, I see some names on the list that I know and many that I don't know, and that's exactly why we're here. We are not going to bore you with statute citations, rules, or case citations. And we could also bore you with 50 plus years from all of us of war stories. That's not our point. Our point is to show you how the three of us went through the 70s, 80s, 90s, meeting each other, hanging out with the old icons of workers' comp from the 40s, 50s, 60s, learning the profession and learning how to interact with each other as well as our clients. So the first question I have is to Ray Malka. And Ray, tell us the procedure that you would use as a claimant's attorney interviewing the client, doing discovery, keeping in contact with the client, and proceeding to the trial within the statutory time period.
Thank you, Steve. Every case, every journey begins with the first step. And the first step for me is the introduction of the client, getting to know them to some extent on a personal basis, to understand their life story and to find out why are they there and can I help them? So that first meeting, I spent a lot of time with the client. And I know the setup for many offices is you have a paralegal who reviews information. I'm sure they do a great job of gathering basic information. But to me, it's essential to meet the person, to get a sense of who they are, set expectations going forward, let them know what you're going to be able to do for them or what you cannot do for them. So part of the initial meeting, and the initial meeting may come in phases, would be to be very careful in gathering information about their past. There are a couple flashpoints, a couple of areas that are particularly important. Prior accidents, prior injuries, prior medical treatment. I ask clients who might say, well, no, I've never been hurt. Well, if you live in Dade County, Florida, you've been in an auto accident. I can assure you of that. Whether you believe you were hurt or not, let me determine that. What happened? Were you taken to an emergency room? Was there a claim? Have you seen a chiropractor in your life? Those are the kinds of questions that I will ask that maybe my paralegal might not cover, but I want to fill in the gaps. The other important point is, depending on the nature of the injury, if you're taken to a hospital, for example, the likelihood is there's going to be blood and urine samples taken. I want to know if that happened. I want to know up front, is there any concern about the potential for an intoxication defense? I explain to them that I can help them best if I know the truth. That's an essential part of the initial interview. Because I'm in South Florida and I represent workers who take the high-risk jobs. Pardon? I represent workers who handle the high-risk jobs.
Is this regarding Marquella Mar? No. Which file is it?
Someone needs to mute out. I want to know about their identity. Are they using a real Social Security number to obtain employment? Have they continued to use that? Again, I'm looking for disasters that I don't want to occur early on. And the best way to find out to avoid those disasters, which is fraud defense, prior injuries, failure to reveal important information medically, is to ask the questions. And I ask those questions. I review them very carefully, and I have that information available when it's time for their deposition to review. But the first step is, can I help the person? Why are they there? And I look at their situation. For example, if you have a police officer or a school teacher, someone who works in the state of Florida, they like their job, they've been there a while, the likelihood is they're going back to work. So the problem they may be presenting with might be a minimal problem as it relates to what you can do for them. And you've got to explain that, for example, the system, this is how the system operates. You don't get to pick the doctors, but you're entitled to care. Providing basic information is part of the service that we need to do. And by providing that information early, you can decide if you can help that person, and only take the cases where you think you're going to have a meaningful impact on what their needs are. If you made the decision that you're going to take the case, then you need to explain how you handle the case. If you have a paralegal or someone that's going to be their main contact point, I'd like to introduce them to that person. Explain that I will gladly speak to them whenever they like, but much of their questions might best be answered by my paralegal. Your checks are not on time. You need medication. We can assist in obtaining information, but this is the person who's going to get the immediate information to you. The next step is, after I've introduced them to how we operate, and maybe set them up with, for example, a pharmacy that Injured Workers Pharmacy is a good resource for claimants to use for purposes of having their clients receive their medication timely without having to make phone calls to my office and us having to contact the carrier for authorization for medication. I take those early steps to facilitate, hopefully, a easy transition from the beginning with this client, getting things set up early on so that their relationship with your office goes as smooth as you can. The next step is this a case you need to file on now? Because someone is hurt doesn't mean you need to file a claim right away. You might be in a situation, for example, and I've had this with what I regard as some of the better employers. An employer says to the worker, we will pay you your full salary while you're out. However, they either hear from the employer or through other workers that if you hire a lawyer, they're not going to pay you your full salary anymore. You need to explain that to the client. So I'm here to help you, but you're getting paid full salary at the present time. You're receiving your medical care. I recognize your injury is very severe. It's going to impact your future. But I think it would be better for you and I to communicate, but not let them know that I'm formally representing you at this time. That's a decision you'll have to make on a case-to-case basis. But it is a decision that I take into consideration on what I do initially. Discovery. What do I need? Well, I need what the carrier has. So I do standard request for production, but I try to tailor that request for production to meet the specific needs of this particular client. Do I need to send any depositions? Well, that of course depends on what is the reason that benefits are being delayed or denied. If it's not apparent to me, I might set the deposition of the adjuster to gather that information and to have some meaningful feedback to my client as to what the problem is. So those are some of the things I do early on in a case. Based on the people that are on this line, I recognize many of my colleagues. I'm sure you all do it pretty much the same way. So I can only emphasize is that the direct contact with the client is essential to a meaningful outcome all around.
Thanks, Ray.
Something I prepared a rebuttal here to what Ray said. No, I happen to think that Ray is about the best there is. And it has nothing to do with the fact that I'm his friend. I can tell you something that he doesn't run around boasting. I do not believe he has ever lost a PTD trial. So when he's talking to you, it's not as a group of general phrases he uses in seminars. This is what he does. And the reason I'm jumping in is because what he says, he doesn't file a PFP right away. He doesn't. And I've lectured to clients at seminars on how to avoid the kind of great white shark style of litigation that Malka has. And that is, if you're the adjuster who's not going to do the right thing, or when Ray writes a letter, get this in the claimant's hands. If you don't get it in the claimant's hands, provided it's at least debatably available, he's going to start pushing other files off his desk, and he's going to start focusing on you because you're exactly the kind of adjuster he loves. A word to the wise. And same thing with claimant defense attorneys who want to lead him astray, beat around the bush with him. He moves other files off his desk to concentrate on that type of person. I've seen it, and I sometimes snicker in my hand when I see it. And occasionally, once or twice a decade, I've had an adjuster that I said, you know what, this adjuster needs Malka to learn.
Let me back up just a minute again, George, because you've led into another topic that both you and Ray can respond to. So I'm going to let Ray go first since you've discussed his excellent reputation. Ray, how did you go about building your reputation, not just with judges, but with other lawyers that maybe could send you cases and building up your reputation, as George said, as one of the finest claimants lawyers around?
Well, I started as many claimants attorneys did. I was a defense attorney for 5 years. I had the good fortune of getting excellent training, having mentors, Bud Adams, Chuck Kelly, who took the time to allow me to observe what they did, explain the reasoning behind certain steps they were taking. And So I had a good foundation from the early years. I saw that they were involved in statewide activities, and I felt that that was the appropriate course that I should take. So fairly early, I got involved in the section. Any involvement, any effort that you make is rewarded by giving you responsibility for putting on a program or participating in a program. So, and I would do that, and I would encourage anyone who is trying to build their practice to engage in the section, engage in your local bar, engage in the inns of court that may be in your community. As it relates to developing a practice, once I left the defense and became a claimant's practice, took whatever walked in the door. And that could be an immigration case, which I did a little of, appointments by judges to do juvenile criminal cases. But ultimately, the people that I knew from the defense end knew me as a claimant's lawyer. And I started to get calls to handle cases. What I always tried to do was have direct and meaningful contact and communication with the referral lawyer, develop a rapport with them, let them know if the case that they were sending me had a third-party aspect that perhaps they didn't consider, letting them know that in handling the comp case, I would be mindful of the fact that there is a third-party case in terms of the doctors that the claimant is being sent to. That communication I found to be essential in developing relationships, which to this day have served me well in terms of the kinds of cases I've been able to obtain. But it wasn't only the senior partners, it would be the associates who may call me with a question which may not lead to a case that I would handle, but I would take the time to answer their questions, to be available to consult with if they had issues in areas that I might be able to help them with, issues of immunity. You know, third-party cases, there is always a concern of, is there immunity? If there's a worker who's hurt, is there going to be a case? Is there going to be an immunity issue? Became knowledgeable on that, was able to help out many lawyers who had to evaluate a case. So basically, communicating with lawyers who send me work, following up with those communications, making myself available, being active in the bar, speaking when being asked to speak is how I developed my practice. As it turned out, many of my early sources of business were those who advertised, heavy advertisers, and I would get their work. Today, much of the practice is also handled by attorneys who advertise or benefit from advertising, but they more likely have attorneys who handle comp currently if they advertise for accident cases. Back when I started, that wasn't the case. The people who were advertising just wanted accident cases. They didn't want to handle the comp. They wanted to handle the auto accident case, so the third-party case stemming from a construction site accident. So that's how I went about trying to develop my practice.
From my standpoint in Central Florida, I did defense work for 2 years and got invited to be the comp lawyer for a large PI firm, large in Tampa. For the plaintiff side was 4 or 5 lawyers, and these guys were all great PI lawyers, and there I was doing the comp. The benefit for me was that this firm had been part of the Perry Nichols firm, which had law firms all over the state, and when they broke up, the firm I was with took the cases they had. So coming in to do comp with these guys, I got to know personal injury lawyers from all over the state, as well as comp lawyers, just for the connection. So I would get referrals from these lawyers that had cases in the Tampa Bay area to handle the comp aspect of it, while they handled the personal injury aspect. So I was able to enhance my own practice based on the firm that I was with. When I opened my own office, just like Ray, I was trying to get these cases for the referral attorneys, move forward as fast as I could for the client, for myself, and for the attorneys, because as a claimant's attorney, you of course had to win to eat. So it was war. You wanted to win the cases, but the war ended at 5 o'clock, and you had relationships with the defense attorneys that you just banged heads with in court, and all of that together spread around. And so I was hopeful and grateful that when I'd go before a judge in a different county, they'd say, "Oh, Mr. Rosen, we've heard of you and we know your partners." And I'd come in there and I'd like to be on equal footing with the local guys. But the big thing was getting involved in legislation for workers' comp. Workers' comp was basically, I guess they call it the main dude back in the 70s and 80s and the 90s. We had special sessions in the legislature just for workers' compensation. It was that big a deal. And Tampa and Central Florida had the big legislation delegation. We had the presidents of the Senate, speakers of the House. Some of them were comp lawyers, but we were able to go to them and talk to them about legislation. And then we'd get the lawyers from South Florida who we knew peripherally through their reputations, but in working together with them, we not only did legislation and lobbying, we had dinner together, we conversed together, we told jokes together, we developed the ski trip together, other conventions, and as the comp business grew, we all got to know each other and learn from these guys. For us in South Florida, it was a whole different world from Tampa. So learning from them how to move the case through was an excellent opportunity for myself as well as other young claimants attorneys. And so moving along a little bit in this seminar, George Kagan is very interesting. He was a great defense attorney at the trial level, but chose to move into the appellate level, where he is one of the best appellate attorneys ever in the workers' compensation system. So we aren't going to talk about how the carriers attorneys got business from the carriers. We're going to ask George to tell us how he was able to move in with the carriers attorneys, self-insureds, and their attorneys in order to handle the appellate aspect of the case.
Well, I'm enjoying hearing everyone's story, and I'll just throw in a word about my own because it leads into your answer. I actually interned for Janet Reno. None of us, it's no shock, but very few of us actually set our minds to being a work comp attorney when we were kids, you know? So Janet Reno had a job freeze, and so I went to work for this firm, Miller Hodges at the time. And Janet Reno called me at the end of the first week with the opening, but I said, you know, I'm kind of happy where I am right now. It was an enjoyable practice. And I think one of the most important things to say is, unlike what some of my friends in other fields think of our practice, I find that I never go into work and have the same day twice or the same case twice. And that's a wonderfully invigorating feeling. But I was hired by two great guys in the field, Jack Miller and Dick Hodges, and they were great mentors. I have some wonderful anecdotal stories I'll skip for now, I have to, but they hated the appeals and they needed the boy. There was always those two and a boy since the 50s. And I was the boy that rotated in, but I decided that, like the alien in the movie, I'm not getting off this ship no matter what they do to me. So I wanted to stay right there. So they walked in with a bunch of appeal files and dumped them on my desk, and here, they're yours. I will tell you one thing that shocked me. If you want to know what the definition of strength, Dick Hodges had a brief that just won at that point. And I said, let me read his brief because the court just ruled in his favor. And he had his statement of the case, statement of the facts, summary of argument, point one, conclusion on page 2. I was like Salieri looking at Mozart's original manuscript. I almost had a heart attack because I always have to fight back from the page limit to say everything I can possibly imagine. And it took great strength to actually say that. But to get back to me, a strange thing happened. I won my first 12 appeals in a row. And all my peers there in Miami were beginning to take notice at about 6 or 7. And wouldn't you know it, number 13 comes along. And I didn't win. And then I became immortal. But that was a great start. And the carriers and the employers took notice of that. And then I stepped out onto the state stage, and I thank Steve Rissman for that, inviting me to give a seminar, and I started giving more, and I soon became very involved in the bar and pretty much had almost every office there, our section. But that gave me the appellate background that has never left me, and that is the work I favored. And now I'm in what I call semi-retirement in my own firm, having left my firm of many years, and all I do is appeals and consultations. Ray and I were experts on a case a couple of years ago. It was funny to see that happen. But a long time ago, I took one claimant's appeal and one claimant's case. The claimant's case, the defense attorney threatened to fight me, wanted to take me outside and fight me. And the appeal resulted in double end bank, with the court winning my case winning the first time and then losing the second time on their second vote. And one of the judges said, "My brethren have told me not to issue this opinion. It follows, colon." And I took that as my sign. Okay, no claimants work. So it's been all defense since then. And I think that I've led in terms of my relationships. I lead with my chin. I'm able to take the first blow or the second blow, but then if I think something's being untoward going on, then I will fight very hard and try to make that attorney never want to do that again. They may win or lose the case, but they won't want to have that experience again, so that I can basically go back to my coasting mode. I won't say coasting, but I don't like to be pushed to that point. So to say, how did I get the clients? I led with my quality. The quality spoke for itself, and I made sure to promote the quality in my statewide dealings. So when we put on seminars, when we spoke for bar functions, everything I did was to feature my own quality as a sort of subtext of what it was that I was doing. And I have not been as aggressive in the absolute marketing, which I think is more predominant today than ever before. And I take that as my own little blessing in my career. But I was able to basically rely on my work and, of course, appropriate amount of marketing, beautiful encounters with my clients. I love my clients, especially to this day. I have clients that have been with me since, I think the first one right now is about 1980. And that's a wonderful feeling, and I really enjoy that. And of course, a lot of my work now comes from referrals from other defense firms that don't want to or are concerned about a particular appeal. And basically, I think it's my reputation. It's the only thing that's drawing me in. And I think I've answered the question.
Ray, thank you, George. Ray, I'd like to ask you to tell us, from the claimant standpoint, what you do to prepare your client, yourself, for the mediation, and how your reactions are with the defense attorney, keeping your clients calm, actions with the mediator. And after that, I'm going to ask you to tell us, assuming the mediation is unsuccessful, what you build for the record. And then we'll go on to George to have George tell us what he likes the defense to have in the record for purposes of appeal after a trial. Right?
Mediations come in multiple forms. It could be a singular issue, or it could be the likelihood that the case is in a posture where you're going to resolve the whole case. And where it's just a singular issue, number one, I want to make certain that I'm prepared and that I understand what the reason is that we're even having an issue. And so that may require, prior to the mediation, scheduling a deposition or a conference with a doctor, or a deposition of adjuster, to flush out what is the basis for why we have this dispute. And that's a single issue kind of situation. But let me go to the more common, which is 90% of cases, whether it be workers' comp, personal injury, any kind of work, settle. The question is, when are they going to settle? Are they going to settle at a state mediation, private mediation, or the day before trial? If it's a case that I think is in a posture to settle, I want to take appropriate steps to make sure that that's what occurs. I typically will make a demand, if it's a case involving a decent amount of money, at least 30 days in advance of the mediation. I provide a detailed demand, and I let them know that if they don't feel we're going anywhere at this mediation because of the terms of the demand, please let me know. I don't like to waste time. I give them that time. I think it's essential for the defense to have that time to have their client evaluate the demand and take steps to obtain appropriate authority. A week before the mediation, I follow up. I attempt to contact the defense attorney and determine, are we going to have a meaningful mediation, or you guys aren't ready, or we're just wasting our time? Typically, in my experience, most attorneys will be straightforward and let you know that, yeah, I think we're going to be able to do something here, or no, not going to happen. It's great. Then let's just do a quick mediation and move on. So preparing in advance, understanding what the issue is that's preventing resolution of that issue, or making a demand early enough for the defense to evaluate the demand and be properly prepared is what I do. The kinds of cases I more typically handle at this stage are typically cases involving career-ending injuries. So many times that requires a Medicare set-aside, for example. If I have a client who is either in Medicare age or likely because of the nature of their injury and the years that they work to become eligible for Social Security disability and ultimately Medicare, then that is taken into consideration. I make that point in my demand letter and advise them that we expect to review a proposed Medicare set-aside agreement. Many times I'll get my own Medicare set-aside proposal so that I can best make a demand tailored to what that aspect of the case will require to settle. So it's money you need to spend up front, but if the case is large enough, I think it's money well spent for multiple reasons. One, it helps you prepare a demand. Two, you can better evaluate their proposed Medicare set-aside by having something to compare it against, rather than just accepting that the proposal that the defense might elicit through their people actually covers the needs of your client. So as it relates to my client, getting back to my original meeting, setting expectations. Now the case has moved along. You're at the point where mediation is appropriate. Settlement might be appropriate. Again, you need to set the expectations. I try to get a feel for what it'll take in my client's mind to resolve the case. I also have typically, if my client has a long-term marriage or spouse, I engage them in that conversation. This is a family decision. It's not a singular decision. If someone has a career-ending injury, it's impacting the family. And I want them involved to some extent in making the decision that's best for the person that's injured. So that's what I try to do, set expectations, provide a demand early, but that pretty much covers it.
Can I mention a couple things, Ray, about
Sure,
what Ray
not
said?
ready. George, one second,
Sure.
because I want you to interact that with the question I have. Since you are not at the trial level, what would you consult with your defense clients and their attorneys as to what should be included in the record in case you have to appeal or it's appealed against your client?
And I'll get to that, but just to throw a few comments in on what Ray said so that we don't pass the moment totally. Some people will use this as a tactic to ask you your money in advance, to tell you what the demand is or we're not going anywhere. And those I brush off because that's just a tactic that I feel intrudes on the negotiating integrity of one party versus the other. So I try to be careful and discriminating. If Ray says it, I know he backs it up. Another thing is if the party invests, Ray invests, I know that. Some attorneys don't invest. We take that into account in our own valuations of a case because we know when the attorney has not invested in the case, the attorney is not going to have all of the things the attorney may be bluffing about. And very often those attorneys have talked their clients into a high valuation to sign up the case, and they need the mediator to talk them off that valuation desperately. But I have so many things to say on the appellate extrapolations I've made that I want to go light on the record. The defense in the trial and workers' comp is not like a lot of other trials. There isn't that much appellate consultation needed, except for a couple of key moments at the end of the case. The things that I would lecture to people, I think, are going to be the things that they would intuitively understand what needs to be in the record. And I don't want to take a lot of time, and don't forget to put in the exhibits that you're mentioning, and don't forget to articulate each theory of your recovery carefully. But because waivers on appeal are very common. But here's where I would start to tie in with what I prepared to talk about in terms of the record. And that is, let's start with final order. Final order. This is a final order. Really? No, it's not. I am really surprised at how often this continues to happen. I'm saying about 20% of the appeals that are referred to me, the JCC has reserved jurisdiction on something, but they caption it final order. And that means nothing to the DCA. If there's any reservation of jurisdiction, they don't want to touch it, not because they're mean, but because they don't want to handle it twice for no good reason. And so there's the Florida Rule 180C, and that says we can review any final order, but also a non-final order that adjudicates jurisdiction, venue, or compensability provided. And there are about 50 words after that word provided. And that must be exactly what the judge puts in a final order reserving jurisdiction, because it's the closest thing we have in modern times to form pleading. The court has ruled that if one word is missing from that declaration that must be in there, it's not an appealable final order. So now that it's dismissal is not with prejudice, because after all, it's premature appeal, but it always results in prejudice to the claimant, because the delay that follows that, this is a state where the employer doesn't have to pay benefits during the pendency of an appeal. And actually, I wrote the appellate rule, which says that we have no right to withhold benefits that are not actually on appeal. You're welcome. So what happens next is I have no hesitation not appealing an order of that kind. Some of my clients get biting their nails. Are you sure? And there are gray area cases where it's safer to appeal and be dismissed than it is to risk the court saying, well, that looked final to me. But if it clearly reserves on TTD, TPD, you name it, that's not going to be addressed by the court. So the quickest thing you do if you get one of those is you immediately have to settle those benefits that are still outstanding if you can. And if not, you'll have to try those benefits. And then you go back to the judge with your stipulation on the benefits. And the judge says, okay, I accept the stipulation. Here's the new order. And it's the final order. No more judicial labors are before me. So that's that. Now let's talk about rehearing. And I'm going to tie rehearing to a huge trap, doesn't come up as often, called cross appeal, trap for the unwary. So rehearing, yes, very often rehearing is indicated. Anytime you see something that is, and I don't think I need to explain to you why you need to file rehearing and when you shouldn't file rehearing. That's pretty basic. But if you have filed for rehearing, and the matter is, let's say this is a great example that leads to my cross appeal. Let's say that you have tried, your judge rules on one of 2 points, and the one they rule on is maybe a point you just threw in, stick it against the wall, see if it sticks, that kind of thing. And the other one was your main one, but you won. You're happy. You won, claimant, or the defense, flip it over. So let's say you or the other files rehearing, and you have to point out, hey, this has not been ruled on. I don't think you can get away with it, even if it's fundamental error that a judge doesn't rule on a point. The court is not particularly unanimous on this in their decisions, but they will more often than not say an appeal is an opportunity to judge the judge on how the judge did, not to make you feel good about your case. And if the judge did not have an opportunity to see his or her error in having omitted that point, we're not going to reverse. You should have filed for rehearing. So most often rehearing. But let's say that the judge denies rehearing and that point still is not ruled on. If you're the claimant and you have won, you don't feel like you have to file a cross appeal, but you must file a cross appeal for that point that you raised that the judge didn't rule on, especially if you thought it was your strong point, because you cannot argue the coachman. That is, that the judge took a crooked path to get to the final result, but got to the right result. You can't argue tick coachman in this situation because A, failure to rule is tantamount to denial under the Betancourt case. It's a denial. You have a denial there in your order, that failure to rule. And B, this is where most attorneys fall down. They cannot supply arguments and findings regarding findings that were not made. The court will not be making any adjustments of findings to help you with your point 2. If it's not zero opposition in law and fact, the court is not going to make your case for you on the ignored point. So I've seen that in maybe 5% of the cases I've dealt with. And another point on rehearing, and this gets to your question more directly, Steve, what about the question I'm often asked, if we tell the judge about this thing we want to attack on rehearing, the judge may improve the order and then hurt our chances for appeal. That is quite often a concern you need to make. And so it's better to err on the side of doing it, but do be careful. If the matter is appealable, you don't want to give the judge a chance to say, I see where I'm vulnerable there. This is sort of an advanced play technique. I'll just throw it out there for you. And here's another advanced play technique that's on my quiet whisper list, and that is, sometimes if you feel like the trial attorney didn't quite put the best foot forward on certain points, you can take that rehearing and participate with the trial attorney as a way to interject comments, concepts, and arguments that were not well developed in the record. Now, there is still the chance the court will kick you out and say, or kick your point out, say, you didn't raise that before the trial judge. But when it's in that rehearing and it's in play, at least you have a toehold on securing that argument for preservation, we're going to call it preserving. This is what we're all talking about, preserving the points in appeal. So that's I think a long-winded answer to your question, and some
very good. At this point, I think that I'm going to interject a little bit of my experience because unlike George and Ray, I have the experience before becoming a JCC of having done claimant and defense work. So there was an opening in Jacksonville that was kind of a mess, and one thing led to another, and I applied and got appointed as a JCC. I've been practicing nearly 40 years, which is probably longer than most judges who came on the bench or come on the bench after their practice time. So I was 60 at the time, and I had the benefit of so much experience with claimant lawyers, defense lawyers, and more importantly, judges all over the state for nearly 40 years. And so in my judgeship, I was able to use all of that experience to take hopefully the good and leave out the bad points of being a judicial appointee. And no question, the appointment of a workers' compensation judge is totally political. Ray and George and I came up in days where there were judges who were appointed who'd never seen a workers' compensation case. They were appointed, they had to learn on the job, which was difficult, certainly for them, but also the practitioners, the staff, and everybody that was involved in moving the case along. And as George and Ray have both stated, the object is to move the case along to some type of conclusion, settlement, or final order. And so that was my goal. I came into the judgeship with the private practice attitude, and I was just moving cases along as fast as I could through the system, keeping lawyers on their toes. You filed this, you better be ready to do this in this period of time, et cetera, et cetera, et cetera. And I was getting out more orders of an evidentiary type, whether they were on the basis of discovery or a final hearing. And I was getting out considerably more orders than the other judges through no fault of my own. I was just a busy beaver. And one of the things I was able to do is that judges from around the state would call me because we had video then, not Zoom, but it was strict video from the judge's office to another judge's office. And if their calendars were too busy, rather than put the case aside, they would call me and say, Steve, can you handle this case by video so it doesn't just sit? And I was happy to do that. And it gave me another great experience of meeting lawyers from all over the state that I had maybe known peripherally or not at all, but I got to see them in action, and that enhanced my judge's ability. The one problem I had as a judge is that, unfortunately, if I didn't like the law, I was in order, using the facts to show that, well, the legislature couldn't have considered all of the potential fact situations like this one. So when they wrote the black letter law, they left the door open, and I'm going to go through that door. So I would structure my orders in such that they couldn't have thought this. They couldn't have considered leaving this claimant out. They couldn't have thought of shutting the defense down from defending this case. And so I'd do my orders, and I, no doubt, got appealed more than any other judge in the state. And I probably got reversed more than any other judge in the state. Just ask George. But I also had a number of cases that were affirmed, and those cases went through the system as they were supposed to. But I always wanted the first DCA to just put learned before judge when they reversed me. And then I would read George's briefs, and I saw it in there that he was knocking me, but he never really said it. And
You
so
picked up
what I wanted to get to basically is the judge, all the lawyers and our friends out of the courtroom. There is no friendship in the courtroom between judges and lawyers. The judge looks at the facts and rules the way the judge should rule based on the evidence. It's the application of the law that can give judges problems. And so fortunately, we have the system of the trial level, the appellate level, and the Supreme Court level where everybody gets their day. And establishing relationships around the state as a judge was unbelievably beneficial to me because I thought I knew everybody when I was a practicing lawyer. But doing video hearings, moving from Jacksonville to Tampa, doing some Lakeland cases, just gave me an incredible outlook and incorporation of what I was looking for from the lawyers and what I wanted them to send to me, give to me, and show to me as evidence. But my bottom line was I basically demanded professionalism from the lawyers, not just to the court, but to themselves. And I am grateful that I got that no matter where I was hearing a case. So Ray and George, would you like to enlarge on that aspect or move on to something else?
Well, Steve, let me ask you a question. My perception is judges are by the fact that they're exposed to the same attorneys, the same witnesses in terms of doctors, rehab people, have preconceptions about what they're likely to say. Is that a fair assessment? Are there in your, when you were a judge, did you kind of weigh the testimony of a doctor whose name comes before you a lot and essentially says the same thing, what on the claimant's end we would call a hired gun, and defense would have the same thing for certain doctors we would use? Or did you try to have a blank slate and ignore the fact that you know this reputation and what they're saying is the same thing they always say in every case? That's a question that I would like to pose to you. How would you handle that situation?
Sure, as a judge, you're the trier of fact. You make the decision, so you're the one that has the perceptions and you have in your mind what certain doctors or other witnesses will say time and time again. What I look for is how they said it in relation to the particular facts in that case in which they testified. If they were just giving a rote opinion, then I may have given greater weight to another opinion that was more based on the particular factual situation and physical condition in that case. So with the judge, it's which is more persuasive under the circumstances of each particular case.
Let me throw out, when I assess a case, and I share this point of view with my former law partners, the three things that I look at early on are who's the carrier, who's the defense attorney, who's the judge, and then down the road, who are the main doctors, who is going to be selected as a rehab person. I can predict the outcome of a case many times by knowing the carrier, their propensities, the defense attorney, do they typically settle or will they try everything? And the judge, what are they likely going to do depending on who you present before them? So I think understanding your opposition and understanding the players in your case is essential to having a good perspective on whether your case is going to be tried and prepare appropriately for that day, or if it's more likely to be a case that's going to be settled because of your past experience and the propensities of the people on the other side. So that's part of what I do, part of what experience allows me to do. And the people that are on the listening can learn from other colleagues through listservs. What's this judge think of this doctor? How does this doctor treat injured workers? Do they typically impose restrictions? Are they likely to operate and then say there's nothing wrong with the person? Basic questions that the answers of which are available out there. And it's important for you as a claimant's lawyer, same with a defense attorney, to have some understanding of the answers to those questions. And the answers are available statewide if you choose to ask people in your community, in the various communities where the case might be being heard.
Let's move that on to George from the appellate level. George, you've got the finished case in your hands, whether you're the appellant or the appellee. And so what are you looking for to protect your client's interests from the trial level as to the same doctors, the same witnesses, the same basic evidence that was presented? How do you support your position on appeal?
Well, having lost to an unrepresented claimant in the early 80s, and remembering it quite well, I take no one for granted on the other side. And I like to, when I lectured to attorneys more frequently in the past, I used to give an Olympic performance analogy. I would say, how much time do you think separates an Olympic 100-meter sprinter from a top college performer? Seconds, many seconds? No, and the answer is statistically fractions of 1 second separate Olympic performance from top collegiate performance. And so I go through a lot of extra effort to be the Olympic performer. And one of them, to take it starting at intake, is to even in rehearing, if I'm asked to draft, I want the judge to see that the drafting is as much a work of art as I can make it. And I polish and repolish, and sometimes it may look like the guy in Beautiful Minds. At the end of the day, I'm talking about this so-called beautiful product I'm issuing. But I want them to understand that this is going to be the top quality product at every step. Now, in terms of what to analyze, first let's touch ethics. I always say that ethics has informed a lot of what we've already said, but I'm always asked, what are the chances for this appeal? Everybody wants to hear you say, what are the chances? And you're supposed to break out a statistic. Well, I start on the curve, and I say that I said that we cannot possibly lose is 80%. That's our chance of success. The reason for that is how many cases that have broken my heart, how many sure things have failed. I have no answers, and I never will for some of the losses that I've had. So I curve 80% is your best possible appeal. And then I say, in terms of ethics, I will take a case where there's a 1% chance of appeal, but I will not take a case with a 0% chance. Now, it happens I won one in the mid-90s, drywall case that I gave a 1% chance to, with staggering, quote unquote from the opinion, staggering losses. I gave them 1% chance, but it was very important for that client economically. And I won. Okay, so once you have done all that you can to give the client the realistic set of what goes on appeal, and very often you'll have the heavy hand of the employer weighing in on what they want to hear you argue up there, what you've got to tell those judges up there. They have to realize that the record becomes the Bible. Nothing can be entered in or out that's not in the record. And so there is a good bit of discipline that has to go on. Now, my serious-minded, regular appealing clients don't need this lecture, but sometimes the employer in back of them does need it. And so I am and this is something I want to make sure I say today, and that is, I'm proud to say that I am just as respected in some quarters for the appeals I have discouraged as those I have taken on. And they include times when they are the appellee. I can think of one case where a destitute guy with a necrotic hip was going to have to pay 49% of his hip. And I said, let's not go all the way with that one. And some of you may know there was a case that was set for the last year's board certification seminar, and they set an oral argument, and it involved Judge Tannenbaum and the two clocks on the statute of limitations cases. And the judge really did load the dice on that one for us, in my opinion. He was very married to the two clock system. He was against en banc rulings spontaneously as part of the judges. I don't want to make this too long. And he was against stare decisis in terms of following. And I'm being unfair to the judge by characterizing them these quickly. So all of these things were put in front of the client, and about 3-4 weeks before the oral argument, they settled that case. And as it turns out, I say with clear conscience, I think two clocks would have been a very difficult administrative burden on everybody. And now Judge Tannenbaum has moved to the Supreme Court. And so for the time being, we ducked the whole 2 o'clock problem by that strategic dive that we took. He's at the Supreme Court now, and it'll take an unusual case to get there. So it's not a dead concept, but there you are. And I've saved for the end, which probably is not even going to get close to get to, some of the illuminating individual stories I have, and one of them involves that sort of thing. So I think I've answered the exact question you set me off on.
One thing I'd like to throw out as far as developing out of court camaraderie, so you have the respect for each other in court because you know each other better. I would meet a new lawyer, whether it was older than me or younger than me, and mostly younger, but I would find out a common denominator. A lot of it was tennis. I think David Drill's on here in Jacksonville, and I didn't know David, a great lawyer, but he always had that kind of edge. So we talked and we went out and played tennis, and it was great. Same thing with Mitch Golden down here. We went out and played tennis and got to know each other. And when we confronted each other in cases, it was only business. We kept our friendships and relationships out of there. So I would encourage you to find a common denominator with the lawyers in your district and get to know them on a personal basis so that when you face each other in court, you will be professional with mutual respect for each other.
I could throw in a comment, if I could. Some people will take advantage of that. And I have a stock answer. I said, I cannot afford a friend who needs me to do them a favor in the litigation itself, settling, etc. We're not talking extensions of time and common courtesies. Those are expected. But every now and then a friend will lean a little bit too much on what friendship means. And I say, I can't afford a friend like that, unfortunately. That's rare, but I just want to throw that in as a spoiler.
So let me make some comments. We have not talked about the trial. And let me share with you some thoughts on that. When we started in the practice, we tried lots of cases. Maybe the level of benefits that were at stake were not that substantial, but the opportunity to present a case before a judge and have a determination made was very common. I could try a case a week. I could try 15, 20 cases a year. That was not uncommon for many years. One thing that I think helped me develop whatever skills that I have is I served as co-counsel with some really good lawyers. Jerry Rosenthal, Gerald Fuhr, Jim Fee. These are lawyers that had cases that they asked me to get involved with. And I learned from them. And so I would encourage the young lawyer or the attorney who's not had a lot of trial experience to take the opportunity to try cases with someone who has more experience. You will learn a lot, whether it be a senior partner in a defense firm or someone who's in your community, a case having consequences that are quite substantial. Enlist the services of someone who's tried a number of cases, if that's the direction of your case, rather than try to cut your teeth on trying a case for the first time. Trying a case is not like mediating a case. It's a whole different deal in how you prepare. And so I would certainly encourage you to try some cases, but to the extent that you can or a little concerned about your ability to see the full picture, co-counsel with another attorney. They will be receptive, and I would recommend you do that.
And that's very good advice. But if you can't do that, an economy way of doing it is what my mentor, Jack Miller, did and what Abraham Lincoln did. And that is go to the courthouse when there's hearings and sit through the entire hearing. Just sit through the entire hearing and do that a few times when some of the top people in your community are wrong. You'll come away better than you were when you started that process.
Stuart, are you there?
Yeah. Before we end this, let me ask a question to Ray. I know you addressed some of it, but focusing back on mediation, of course, it's confidential. The judge never hears about the conduct or the comments of the attorneys. What is your feeling as to whether it is a plus or a minus to go the scorched earth approach or a more conciliatory approach as attorneys during a mediation? Does it matter one way or another, in your opinion?
Let me answer it this way. If if I think the adjuster has done a good job in the handling of a case, I'll start a mediation by letting them know that I appreciate what they've done. So that'll be the situation where it's not, quote, a scorched earth approach. We have a value to the case. We recognize that you maybe think differently about the full value of the case, but this is why I believe the case has this value. I try to give an opening in most cases, and I do the opening for a purpose. One, my client hasn't had an opportunity to hear me speak, and I want to make certain they understand that I understand their situation. And I want to make certain that the defense has fully understood the perspective that we're bringing to the mediation. Uh, and I'm assuming they've spoken to their client, and their client probably has listened, but many times at the mediation is when they're really paying attention. So I try to do that. With respect to scorched earth, if it's a case where there's been battling all along, well, my battlings has occurred before the mediation. I've deposed the adjuster. I probably have scheduled the deposition of the primary doctors. I have my IME lined up. So I don't treat it as scorched earth, but I do it as appropriate preparation to make certain that they appreciate that if we don't settle the case, we're ready to go. I'm not going to start preparing. We're ready to go. I've already done much of the work that's necessary. The other depositions are scheduled or will be scheduled shortly. And now it's your choice to evaluate the case properly and bring it to a conclusion. That's how I try to approach a mediation.
Thanks, Ray. I want to thank Steve, Ray, and George, and Judge Langham, if you're still there, if you could post the information with regard to CLE and CEU across the screen, that would be very helpful. There we go.
All right, well, thank you all for allowing me to participate with my longtime friends, Ray and George. Thank you, Stuart.
Thank you, everyone. Have a great day.
Thanks, everybody.
So I'm leaving this up, Dr. Suskin, in case anybody is still scribbling down. I'm going to stay for a couple more minutes. I should have gotten on while there were more people on. I just want to say to you publicly, though, that was frankly incredible.
Thank you.
I can't give you a better adjective than that. What a way to kick off a program. 100 years of workers' comp experience on the screen today. Um, that's amazing.
Yeah, I really enjoyed it. I really appreciate. Looks like the guys are gone, um, and just a few of us remaining. But yeah, I thought it went very well, and thank you for you handled the technology brilliantly.
Well,
Thank you.
we're gonna do better. We're gonna grow in our knowledge and our ability to do this, and it's fantastic. I'm gonna go ahead and turn off the recording and remain muted. And then as I see these folks drop off, I'll close this out when the time is right.
I,
Excellent. Thank you. Go
excuse
ahead.
me, I so hate to bother you. Hi, Stuart. It was a great seminar. This is Sharon Hendon. I'm trying to read the CLE number and I cannot.
Oh, okay. You ready?
Yeah, go ahead. Thank you. It
It's
was great, by the way. Absolutely great.
thanks. It's 25 17 529N.
Thanks so